Talk shoes. Recorded live.
Okay, can you hear me?
All right, Carl?
Yeah, the two guests that we have tonight, ladies and gentlemen, and we're trying to find them. They're in Dallas area, Texas. Should be on the board there. We have, hold on a minute. Dang, computer's slow for some reason.
Well, yeah, I'm losing my iPad here. The two guys that you have, if they will hit their star 8, that should flag them for me to be able to unmute them.
Yeah, push it. Okay, we have Bob McNeil on with us tonight, and we also have Michael Ellis. And these two gentlemen have tried to file in the Harold Stanley IRS case, scam case, let me rephrase that. Harold's sitting incarcerated right now. Anyway, Bob and Michael, if you will hit your star 8, that will flag the screen, and Rod can bring you in the call.
I did already. This is Michael. And this is Bob.
Okay. You guys are good to go. I'm not going to do a whole lot of talking here. I've been coughing again. I got my coughing spell, so I'm going to let Carl handle this with you guys and talk here tonight. So you guys got the floor, and go ahead.
Okay. Ladies and gentlemen, first of all, Rod and I have been talking here past week or so. We have a so-called new president. As some of you know, we've been lobbying for years, and I just brought it up. I think it's time to go back to D.C. and walk them hallways again. Why I say that is because the head of the Senate and House Judiciary Committee chairs and members are going to change. Everything went from Democrat to Republican. And we don't know until we get there what we can do, but I'm looking at spring to make another trip up there. And, of course, we're going to ask for help with funding. Also, we're waiting on Rod's surgery on his knee to see when we're going to do the next private attorney general school, either at his new place or here at mine. So that's coming up in the future. I just wanted to let that get out there. We had Michael Ellis and Bob McNeil on it with us tonight. And I'm just going to turn it over to them and let them explain what they've been doing, how come they entered the Harold Stanley case, the forensic audit stuff. And so, Bob, if you want to do an introduction, why, the mic's open.
Sure, I'll be glad to, Carl. Thank you. My name is Bob McNeil. I have a website called ram-v-irs.com. And on that website, I've been battling the IRS for a number of years now. And on that website, I publish all of my documents, correspondence that has been sent back and forth between me and the IRS. I met Michael in 2014 when he approached me to say, hey, Bob, I have found evidence of computer fraud committed by the IRS deep within the individual master file system, and I wonder if you would take a look at it, because I have about 40 years of experience as an accountant and a forensic auditor in the oil and gas industry. So I met with Michael, and I looked at his evidence, and sure enough, it didn't take me but just a few minutes to see the fraud was staring me right in the face. So Michael and I have been working together since 2014. Michael filed a case with the District Court in Washington, D.C. I filed my similar case in August of 2015 in Washington, D.C., the District Court there. And we have now worked with a number of plaintiffs who have been harmed similarly as we have. And we have filed a total of 12 cases now in the District Court of Washington, D.C., and we have just, we're getting ready to have, I think, the 13th plaintiff file hers, but hers will be filed out in California. But just to jump real quickly, though, to the Harold Stanley case, as a result of my website, I get messages all the time from people all around the country contacting me. There's a contact RAM button on my website, and when someone contacts me, I get an email. And typically it's their name and their email address and any other information they want to put into that message block. Well, on November 14th of this year, I received a message from Harold Stanley. And as you all know, he was convicted in June of 2016 and was due to be sentenced on the 16th of November. Well, this message came on the 14th of November, and this is what it said. I'm reading it right now. The IRS has railroaded me and would not let any of my testimony for my case to be heard. They are trying to put me in prison for 5 to 8 years for tax years 2005 through 2013. Please help. So this was 2 days before his sentencing when he contacted me, and so I responded to him and said, well, if you'll give me a call, we can talk on the phone, and then we can see what we can do from there. Well, he did, and I asked him if he would send me a copy of his individual master file, the IMF transcript complete, or the transcript complete, and he did that on the 15th actually of November, the night before he was going to be sentenced. Well, I took a look at his IMF and saw right away the same pattern of transaction codes that on his IMF that Michael and I had seen on every other IMF that we had observed. And I knew right away that it appeared that Harold Stanley had been convicted based on fraudulent information. So that's how we entered the Stanley case. Of course, Harold was sentenced on the 16th. The judge sentenced him to 8 years in prison. He was taken into detention immediately after the sentencing hearing, and we have been now working with his wife Lorraine to work out how we can help Harold in his case. Having said all that, I'd like to turn it over now to Michael so he could embellish that and add what he'd like to, and maybe explain what we've done so far.
Yeah. Bob, can you share with the listeners what IMF means?
IMF stands for the Individual Master File. The Internal Revenue Service has basically two computer systems. One is called AIMS, A-I-M-S, which stands for Audit Information Management System. And then there's the IMF, which stands for Individual Master File. Every person, every individual who has ever filed a return, and even some who haven't, has on file an individual master file with the IRS deep in their computer system. So that IMF contains all of the transactions that have ever been conducted between you and the IMF. And so through a FOIA, a Freedom of Information Act request, we used to be able to get copies of the printouts from the individual master file. But about a year or two ago, the IRS stopped providing those, and now they only provide what's called an account transcript, which is sort of a stripped-down version of the individual master file that they used to provide. It doesn't have quite as much information. However, it still does have the transaction codes that we find are the source of the fraud. So with that, if I've answered that question enough, I will turn it over to Michael.
Okay. So what we have found, to get to the chase, is that the IRS, as Bob has said, has to maintain for every person an individual master file record in their software. It's actually called the ECC. It's the Enterprise Computing Center in Martinsburg, West Virginia. By the way, the word enterprise should capture some people's attention because we're not enterprises, but they make us look like we are. At any rate, in the Enterprise Computing Center in Martinsburg, West Virginia, they run this thing called the individual master file software to record every interaction between an American and between the IRS, so that they have a record later they can go back to and say exactly what has occurred with respect to that individual. So the individual master file record, Carl, that we were talking about, has this other adjunct computer system that's tied to it, as Bob mentioned. The AIMS computer system has actually the software, and it's closely aligned to the IMF software. The AIMS, as Bob mentioned, is the Audit Information Management System, and it was created for what they call the Examinations Division of IRS. You know, IRS has several divisions, collections and so forth, but Examinations had a software program created for them called the AIMS software so that they could track and control documents related to any audits that they did of returns. So the AIMS and the IMF software are very closely related. The users don't know that they're two different systems, but they have two different documents that the IRS puts out that you can study to see the difference and to learn exactly how they operate, these two software programs. So long story, I want to get to this point so that people listening don't get too tired. The IRS has to falsify its records, we have discovered, whenever it deals with a person that the IRS labels a non-filer. They used to call non-filers. In fact, Congress passed a law so that IRS can't call non-filers weird names like anti-government constitutionalists and tax cheats. The DOJ, of course, is excluded from that, so they call you whatever they want to. But the IRS can only call you a non-filer if you're one of those who has not filed and sworn out under penalty of perjury a 1040 form for them, or 1040A, or variant thereof. So whenever dealing with a non-filer, ladies and gentlemen, a quote-unquote non-filer, we have discovered that IRS has to commit a certain sequence of fraudulent transactions. We would call it white-collar crime. Congress definitely calls it a crime to falsify federal records. So not to bore you, but at what's called the Criminal Code, it's 18, United States Code, Section 1001. If anybody falsifies a federal record, why, that's a crime and it's a felony. If anybody knowingly uses a falsified federal record, well, that's another crime under 18 U.S.C. 1001. So what we found is whenever IRS begins the process of attacking a non-filer before they can do anything, their software requires that they make it appear that the software thinks that a return was received, either one filed by the target or one that IRS created. Now, the IRS does have authority in certain limited areas to create substitute income tax, or shall we say substitute tax returns. That's only though the IRS is multiple places said their authority under what's called Section 6020B of the Internal Revenue Code allows them to create substitute income tax returns in excise tax cases, in employment tax cases, and in the third one, partnership. The income tax is none of those three. The income tax is not excise tax, employment tax, or partnership matters. And so we find that the IRS has admitted publicly, multiple places, they have no authority to perform what we could call a substitute income tax return. So to prosecute those people, I got to back up one sentence. The software programs that the IRS uses were created to perfectly mirror how things get processed in the IRS. So when they began the process of making everything computerized in the 80s, they tracked carefully exactly how the IRS took every piece of paper and controlled it and filed it and so forth. And what came out was a system of software that perfectly mimics the lack of authority of IRS to perform substitute for returns in income tax cases. Carl, the reason why they falsify their records is to conceal that fact, that they have no authority under 6020B to deal with income tax, quote, non-filers. So they take this extensive sequence of computer interaction and documentary fraud based on top of that to conceal the fact that they want it to look like the record shows the Internal Revenue individual master file record for any given, quote, non-filer that they want to attack shows that IRS supposedly performed a substitute income tax return on claimed dates for that person, when in fact no such thing exists. It's
without a signature?
Without anything. There's nothing that exists at all.
So so you're saying that they're just creating
by computer fraud. Yes, they use two little computer, what they call, and let's say this for your benefit, every entry into the individual master file record has a number. You can only make an entry into a master file record by doing what they call a transaction. That means you have to enter a three-digit code number. And when you want to do something, make an entry into an individual master file record, you have only a certain few hundred. I mean, there's many different transaction possibilities, but you have to choose from the ones that are available. So to make the phrase SFR 150 show up in the individual master file record for any given year of a quote-unquote non-filer, they do a two-step transaction that includes what they call a 424 transaction that contains an 036 override code. By doing that two-step transaction simultaneously, bam, bam, in the AIMS software, it automatically produces over in the individual master file record the words return received date with a date sitting there, and then later it will automatically produce the word or the phrase SFR 150 with a date beside that. When in fact, we've done FOIA requests for any documents related to those entries, and IRS has disclosed that there is no document whatsoever responsive to your request. These are computer-generated transactions.
Well, does anybody know who's the author of that software?
Yeah, well, we're working very hard to get that. It's called the source code. So we'd like to get that. One of our cases in California, one of our friends, the lawyers were trying to get that, and the government stonewalled it. No, we don't want to do that. It's not relevant, blah, 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 blah. We give you reasons why. But the source code will tell us, Carl, as your mind is tracking correctly, will tell you who created it and for what particular purposes that transaction code number was created to perform. And since there is no authorization under 6020B to perform substitute income tax returns.
No.
There is no transaction code in the individual master file software to be able to enter any data from a substitute income tax return.
Well, Harold Stanley put Rod and I as Harold Stanley put Rod and I on the stand under oath at pretrial up in this kangaroo so-called IRS court. They don't even have a tax clerk up there. I walked into the clerk's office and asked for the tax clerk, and, well, we don't know. We don't have a tax clerk. So, anyway, Harold put us both under oath, and we was going to pretrial to testify what we were going to testify at trial under oath. So Harold asked us what we were going to testify to, and I just blatantly said, well, Federal Judge Edith Jones back in 2005 said that these court systems are corrupt beyond imagination. And I said, the second thing...
Where did you hear that, Carl?
Huh?
Where did you hear that? Where did she write that?
I'm sorry?
Where did Edith Jones of the Fifth Circuit Court of Appeals write those words?
Yeah, Federal Judge Edith Jones told in a lecture at Harvard School that the court system is corrupt.
You show us that? We'd love to see that.
Yeah, you can Google it. Federal Judge Edith Jones. So anyway, I said that, and also looked at the judge, and I said, well, from my understanding, the evidence that we have in our exhibits is all taxes are voluntary. And I looked at Harold, and I said, Harold, I haven't paid taxes in 20 years. I haven't signed a 1040. I ain't signed anything. And I'm okay, you know. I'm not Donald Trump, got gold on my armchairs, but, you know, I'm surviving. I'm happy. And so the judge spoke up and said, well, I brought up the little brown book. I don't know if you've had a chance to look at that yet or not, but this agent book that we're not supposed to have, somebody sent Rod and I a copy of it. Handbook for Special Agents, Criminal Investigation, Intelligence Division, Internal Revenue Service. Agents, our tax system is based on individual self-assessment and voluntary compliance. The material contained in this handbook is confidential in character. It must not, under any circumstances, be made available to persons outside the service. Mr. Mortimer Kaplan, Internal Revenue Service Commissioner. The federal prosecutor told the judge that this book was published back in 1980, so she struck it from the record because it was too old. Now, if you turn to page 9781-262, paragraph 415.22, willful failure to pay. This offense applies to the willful failure to pay any type of tax, including estimated taxes. The elements of this offense are that the person was under a duty to pay a tax which was due and owing, that she failed to pay such tax at the time or times required by law. What law? Here we go with the law thing. Or regulations, and that the failure to pay was willful. The mere failure to pay the tax is not a crime. I'm reading this out of one of their manuals that they use, that they go by. And, you know, this is getting more interesting. I wish we would have hooked up here years ago when Rod and I started following some of our IRS cases. We just keep finding ink on white paper and using it back at them. And, of course, they don't like it. But, you know, it's up to people like us. And I'm impressed with what I read and seen, what you guys filed in the Harold Stanley case. Of course, you know, I say, well, who am I? But we've been in it 20 years, so where do you guys plan on? What's your go? What is your go to accomplish within the next year?
Well, we really, Carl, don't put any long-term plans out. That's not what we do. We simply go through the doors that God has opened already. So we have met many people who have been, shall we say, attacked by the IRS using falsified records to make it look like the IRS performed substitute for returns on dates that nothing happened. Falsifying government records is a crime, and for those who are listening, it's really useful to understand this. The Constitution limits federal officers to only doing things that are lawful. No government employee can be authorized by Congress to commit crimes. So the fact that the IRS institutionally, that means in failing, systematically falsifies its records concerning non-filers in a particular sequence, that's a crime, and it tells you that Congress did not impose any duty on that person that's the target of the criminal activity. Let me say it this way. If Congress imposed a duty on Americans that requires the commission and concealment of crimes by government agents to enforce it, that doesn't make any sense. Congress never would be able to impose a duty upon us that requires a surreptitious commission of criminal acts by government agents. The bottom line to that thought pattern right there is that Congress did not impose the tax on anyone because, and the proof is, that the government is committing criminal acts to enforce it on those who are quote-unquote non-filers. So I'm saying that to just let you know, our goal is simply to just go one step at a time, helping people who have been hurt, Americans who have been hurt by the IRS just as we have been, who've had their lives altered by the IRS just as we have been, and who have been wronged by the government commission, not only of criminal acts to falsify federal records, IRS records, but by the Department of Justice, who is concealing the underlying IRS record falsification program. We have found that in the Attorney General's tax manual for prosecutors, he expressly states and tells these prosecutors in every one of the 50 states, don't give out the individual master file software record. As Bob mentioned, that's called IMS transcript, complete or individual, depending on which year you're talking about. But the IRS transcripts have evidence in them, the IRS individual master file records have evidence that you can see where IRS falsified the records. So the Department of Justice knows about that falsification of the IRS records and conceals it by, instead of presenting copies of the individual master file records to courts, they just present, as Bob has said, certifications, account transcripts, all sorts of BS paperwork to conceal the underlying falsified individual master file records. I say that to say we've caught the government, that's the IRS, falsifying its records We've caught the Department of Justice concealing it, and we have sued them both relentlessly for the last 2 or 3 years, and there is a very interesting groundswell beginning to happen. And here's the next thing that happened. The courts themselves were really not geared to commit crimes to. But our court system, when it started to hear, the judge who first heard our case, a case on this issue, was named Judge Amy Berman Jackson in the District of Columbia District Court. Judge Jackson got confused. I don't think she's an evil person. She just didn't really understand. She did a little research, though, and figured out that our case sounded like another case. So instead of dealing with our allegations, she substituted the allegations from the other case that was in another circuit. Let me give you real specifics. Our case alleges, and these are all the allegations similar to every person who's filed a case in D.C. or anywhere, is that IRS falsifies the records to make it look like they perform substitute income tax returns on given dates when they don't on any date perform substitute income tax returns because of constitutional limitations or issues that your revenue officer's handbook specifically shows and states. Right? Making sense so far?
I'm with you.
All right, so now we get this judge who's looking at this weird thing coming out of the blue, our case, that says IRS is falsifying its records and DOJ is concealing that and using falsified records presented by the IRS to conceal that underlying IMF record. She turned the allegation and says, at bottom, plaintiff is attempting to stop the IRS from performing or preparing substitutes for return. 7 times in her dismissal order, she said that. So it's apparently important to her, but it's a complete misstatement of the allegation. Again, Carl, our core allegation, IRS never performed substitute income tax returns on any date, let alone those falsified dates in the individual master file records of Harold Stanley, Michael Ellis, Bob McNeil, and anybody else they target as a quote-unquote non-filer. So the judge thus changed the case, and she has no authority to do that. She can only take the allegations of the complaint and read them, not substitute allegations she wants to adjudicate. So we've been finding that the courts themselves, with the help, active participation of the defendant Department of Justice, are consistently now claiming, every chance they open their mouth, they claim that we are supposedly attempting to enjoin, that means to stop, IRS from preparing substitute income tax returns. When in fact, our court complaint calls it, they don't exist. Substitute income tax returns do not exist. So, the bottom line is that the courts are involved with the DOJ and the IRS in preventing us from getting relief to this stage. But we have to say this. We've had some interesting developments lately, and we really think that there are judges with integrity that see this as a problem, that see this criminal enterprise that IRS and DOJ are running is not right, and who might join us to stop it. So what we try to do, Carl, is not to assault all attorneys or call them kangaroo courts. We are actually just, we love the rule of law that was not established by, any little people. It's a concept that comes from God, and that the attorneys are many of them have integrity. They have no idea that the IRS is doing this. So we are attempting to make common cause, to build consensus with attorneys whose consciences are stricken by this horrific damage that the IRS is doing with its falsified records. So we are bringing Harold Stanley's case up over and over in all the documents we're filing in Washington, D.C. and elsewhere to let people know this is not some faceless problem. Somebody was put in jail on 16 November for a supposed crime that the government had to create by fraud. That's not acceptable to any of us, human beings, and we're here to help the attorneys to stop the fraud. So kind of a different approach because we're not trying to savage the attorneys. We're trying to stop the fraud, build common cause with attorneys with integrity, and we think that we've got a little bit of traction in the courts of appeals. We don't know for sure, but we're looking forward to whatever door opens, Carl. So we're not sitting still. We're pounding on doors. Our only goal is to terminate the IRS and DOJ record falsification program by whatever means it takes. So we have filed these cases, numerous cases, in the District of Columbia and elsewhere now. They're starting so that we can provide the groundswell so that people, the courts can know this isn't just some isolated weirdo that's complaining. This is every single person that IRS calls a non-filer has been attacked by the criminal. Now, to start off the IRS program of attacking a non-filer, they have to commit a crime. That's a problem. And the government, our courts, cannot participate in anything remotely related to sanctioning. In other words, in a nice way that's saying supporting any criminal acts. So our courts are on notice that something is really bad happening, and we believe it's just a matter of time till the right attorneys with integrity take a look at this and say, stop it.
Well, amen. Have you considered, or you and Bob considered, in filing in the Federal Court of Claims Court? We have a case pending that's supposed to be an administrative court to bring charges against the administrative side, people, etc. That court is supposed to oversee the administrative of the other courts, and we have that Harold Stanley case pending in the Federal Court of Claims, and we're waiting on the IRS and the Department of Justice to answer. Here again, we're assisting Harold Stanley, and we're assisting others.
So what does the complaint consist of?
I'm sorry?
What does the complaint that Harold or you filed in the Federal Court of Claims consist of? What's the complaint? What's the claim?
Fraud.
Okay.
RICO. Racketeering.
Oh, okay.
Yeah, I'll email you a copy of the petition.
All right. Do you think that, have you been in the Court of Federal Claims before? I hear you have.
Yeah, we filed a case for Roger Tanner years ago. He had a judgment up in Ohio, and he's having a hard time collecting on it, and he actually sued the judge. And the paperwork showed that there was a judgment issued from another judge against this other judge, and it was a pretty peculiar case. So Rod and I was up in D.C. one time, and I said, well, hell, I'll just stay in a motel room here today and type that petition, go file it in the Federal Court of Claims, because that's, and Rod gets more into that. I don't know if he wants to talk about that a little bit or not, but he's got a case actually in a administrative court down in North Carolina that he just got a hearing date for. So, you know, you think 20 years you would know just about everything, but we're still, it's like you guys, you know. I mean, I never heard of you. You guys probably never heard of us, but, you know, it's up to us. We need more Bobs and Michaels and Rods and Carls and Harveys and others. We need more people. We need more people doing what we're doing. bringing it forward, creating a record, file, create that record. If they want to dismiss it, then dismiss it.
Yeah.
Rod, are you on here? Can you talk?
Yeah, I can talk in between my coughing. All right. What we've done, guys, is I've got a claim here in North Carolina against a county judge, prosecutor, state highway patrol. I went and got them for breach of their duty. The Industrial Commission, if you look at what Harvey posted, it is a workman's comp court that deals with workman's comp claim. You'll see there's probably about 10 or 12 cases, and they deal with businesses. I'm the only one that is dealing with North Carolina. So we are bringing a workman's comp claim against North Carolina because every time the state claims an injury against us, this is a workman's comp claim. This is how they're collecting on us. That's how we found out. So we've got a hearing on January 30th at 9 o'clock in the morning. I have a gentleman that I've been working with on an IRS issue. We found it in the tax court in Washington, D.C. We're coming back in and we are showing the misrepresentation of how the 16th Amendment is being misquoted by the IRS agents. We went back and got into the Supreme Court case site. I think the gentleman's name was Bushnell. All right. He failed to pay taxes, and he won his first case. Congress went back in and readjusted the 16th Amendment. There was nothing new added to it, no new people. But they closed a loophole in this. What happened was this. The gentleman worked for the railroad for construction. Because he was taking federal funding, this is the key words here, he was accepting federal funding off of this. While he was being paid with federal funding, he invested it in homes and property and stocks. Well, because it was federal funding, he had to pay taxes on it. If it was non-federal funding, then he would not have to pay taxes. But because it came from the federal government, he was required to pay tax because it was an income. There was another gentleman that was in the military. He bought a lottery ticket. Because he used his military pension, which was VA, which was military government, he had to pay taxes on the lottery ticket. These were the emphasis. This is what IRS is leaving out. This is what your attorneys are leaving out. We've got a hold of a 1942 Congressional documentation that went in and explained about the IRS, went back and explained about taxes. And it went in and said the average person, if we pay taxes, all we have to do is do a tax return, and they are to pay us back in full. They was not supposed to keep anything because it was not up to the civilian side to pay taxes. This was strictly public officials. And we're pulling the congressional records from Congress out of this, from 1942, 1938, 1935. Well, all this stuff is being laid out. So we laid this before the tax court. We put in over 300 documents that went back in and exposed the fraud of how they are misusing the 16th Amendment, how they are coming in and frauding the people on this. So this is going to be very interesting because we actually went back and showed the 16th Amendment did not create any new taxpayers. It was to charge public officials, not John Q. Public. We've got our hands on 2 documents from Congress where a couple guys went in and challenged 6331A on how the IRS is intentionally, deliberately leaving this out on these liens. And these 2 congressmen came back and said, well, we're going to send this to our legal department. But if they are leaving out Section A, then this is misrepresentation of what they are doing. And this is fraud, because it is up to public officials to pay taxes, not to private citizens. So this is what I've gotten involved with. This is what we are filing in, and how we're going after this through legislative enactments of legislation of being on the floor of Congress and their minute orders. So we are going administratively to the tax court. So when we went there, we took it to the clerk of court. The clerk of court sat down and said there will be somebody within 2 weeks that will contact us. It will be a negotiator that was come down to Winston-Salem that would sit down and negotiate this with us and then settle this, which is a whole different ballgame, because what we've discovered, ladies and gentlemen, is what I have been teaching. We are dealing with agencies. And according to Title V, under 3105, administrative law judges, it shows that any and all agencies, they are to have their own separate administrative law judges. So what we're saying is, if it is an agency, they are to have their own administrative judges. It isn't one judge for all the administrations. It is judge per agency. And this is why when we're going into this district court of the United States, that's the wrong venue. That's the wrong jurisdiction. This is not an administrative law judge. This is a judicial. And administration is bringing this into the wrong venue. This is why we have to run administrative. This is why we're bringing up all the congressional records and putting the congressional records in of showing why John Q. Public does not have to pay taxes. It is strictly for federal and state employees or county employees or city employees. There are two groups of people. There are the civilians, which is us, and those who work for the system, which is them. And we even have the terminology for definitions of what an employee is and how it lays out. And it lays it out to their side of the fence. This is what we're putting in for evidence. So we're exposing the legislative fraud before the IRS court in D.C. That's what we got going, ladies and gentlemen. Like I said, we're pushing it. We got over 300 pages in.
Okay, but I'm going to give you a break here, Rod. Bob.
Yes.
Do you and Michael agree that all personal so-called income taxes, I guess I'll say it that way, on individuals that's not internal that's not an employee internally in the corporation government, that taxes are voluntary to we the people?
This is what we have discovered, and this is through the government-supplied documents, and that is that the only thing that ties us, we the people, to the government's ability or authority to assess taxes against us is our signature under oath on the 1040 form.
Amen. I concur.
Yeah, and that's the government. We've got that as evidence in all of our documents. So for those quote-unquote non-filers who don't sign or file a 1040, based on what the government says, there is no authority for them to assess or collect taxes against anyone who doesn't sign under penalty of perjury. Did I state that correctly, Michael?
Yes, and that explains, Bob, the existence of the IRS Individual Master File Record Falsification Program. Because if they don't have any authority under 6020B to summarily assess without you having signed a 1040, then they have to falsify the records to make it look like you filed one. That's what's the dynamic coolness of what we've discovered is we all know, we hear them say that it's voluntary compliance But if you don't volunteer, they come after you with criminal charges.
Yes.
How does that work? Where's the disconnect? And we found it. It's in the individual master file records, but they falsify them to make it look like they have performed a substitute for return for income tax, which does not exist. Once they do that, then they're off and running. So that's where Bob and I and the people that we work with are attempting to very carefully enjoin that fraud. Stop making the individual master file records of your victims reflect that you performed a substitute for return on given dates when all you did was a sequence of transactions called computer fraud to get the records to look like you did a substitute for return, but you don't because you have no authority to do them. So that brings up this question. Carl and Rod, have you taken a look at what we have been filing, what we filed for Harold, for example? Did you get a chance to look at that, Rod? Okay. We're wondering if you have any thoughts about, what's going on in that case in the Federal Court of Claims. Are you going to be able to use this information? But either way, whether you can or not in that case, we want to file a...
Yeah. Rod and I have discussed this. We're waiting on the defendant's answer. The Federal Court of Claims, when you file a case in the Federal Court of Claims, the Federal Court of Claims clerk serves the defendants. They do the service. They serve the defendants. However, it's not 20 days, it's 60 days for them to reply. So we're waiting for that 60-day umbrella threshold to occur, and then Rod and I are going to refile our entry of appearances as private attorney general that was recognized by Congress. And, we got our own seals and stamps, and we've been using them. I do want to just briefly mention, Anthony Williams got convicted for unauthorized practice of law using the private attorney general heading, and he got some time over that. So I want to re-emphasize people that you have to know this is a team effort. If you got an ego and you want to be Donald Trump, then go do it. But what Anthony Williams should have did was at least get a hold of Rod and I and concurred with us, and we could have helped him out. Now we have a conviction against the private attorney general because somebody had a high ego and they wanted to make a name for themselves. If I'm wrong, I apologize. If Anthony is on here listening to this, I apologize. However, we have been cautioning people for years. You have 20 years in the courts and research, and I don't know how many archives we have on AIB on this talk show. Surprising that the recordings are still on here. But anyway, back to Harold Stanley. My prayers and I was so upset that day and I walked up to the table. The judge came in and made me go back in the pews, and this courtroom, and you could tell it was a new building. It was like the Romans crucifying Jesus. And it just, I had a tear in my eye when I walked out of there, and I thought, wow, man. RICO was designed for the mob. But now we have a system of some, and let me say that again, some we have a tendency to play this word game with lawyers, and some attorneys and judges are just blatantly crooks. They're worse than the mob.
All right. Well, we have just a couple minutes, and we have to go now. But I just wanted to ask you again specifically: do you have any way to use this information that we've created for Harold in the Eighth Circuit?
Yes, by your permission, we're going to file our entry of appearances in the Federal Court of Claims case again, and we would like to get back with you guys before we do that and share documents, paperwork, etc., to keep that case open. I'm sure Lorraine's listening to us tonight, so anyway, anything else you guys want to share?
Well, that's it. We really needed to know where you were going, so please keep us apprised, and we're going to talk also about a Rule 60B motion for fraud in the court into the trial judge because of the concealment of this exculpatory evidence. So that's something we're thinking or doing right now as well.
Yeah, well, good. My hat's off to you.
Yeah.
All right.
Carl, this is Bob. Could I interject something real quickly for your listeners? For those who have not seen the document that Michael and I helped write and gave to Lorraine and that Harold filed, you can see it on ram-v-irs.com. It's in my latest blog. There's a link to it. But real briefly, what we did on, Harold was convicted on November 16th. We worked through Thanksgiving, and on December 5th, or thereabouts, Harold filed this document. The title of it is Appellant's Motion for Summary Reversal Based on Newly Discovered Evidence and Motion to Set Immediate Hearing. His case now is in the Eighth Circuit Court of Appeals in St. Louis, Missouri. So that's where this document was filed. And it didn't take the court very long. It was filed December 5th. The court denied the motion on December 14th with a single sentence. Unsigned, the order was unsigned by a judge. It only had the clerk's name on it, and this is all the order said. Appellant's motion for summary reversal is denied.
Well,
so that's the current status of Harold's case as far as any documents that we've assisted with. I think Harold now is attempting to get counsel. He's filed the financial forms to do that, to have the court appoint counsel for him. And we're continuing to talk to Lorraine frequently about what's going on. So, and Michael just said that we're considering a Rule 60 motion soon. So if anybody wants to read the document, the motion, it's out on my website, ram-v-irs.com. The motion itself is only 6 pages long. The entire document is 160 with all the evidence that is included in that. There's a memorandum of law in support. There's also a statement of incontrovertible facts in support of this appellant's motion. So it's an extensive document, but it mirrors exactly what we've been talking about tonight, the internal IMF fraud committed by the IRS.
It lays it all out in Technicolor, too. So if anybody is interested to see it, we would love for you to look at it and tell us what you think of it, because it is irrefutable, what we call incontrovertible, because it all comes right out of the government's documentation.
That's great. That's good.
Yeah, and you'll see all that evidence that's included in that document. It's just you scroll through and take a look at it, and it becomes quite clear what we've been talking about tonight. You'll actually be able to see it on the documents themselves.
So
Lorraine just posted on the message board here, January the 9th is the due date. So we're going to try to stay on top of that one, guys. And my hat's off to you for what you're doing here. Like I said, it's not It's we the people. We just got to get more people involved, and we got this class we're going to do again coming up, and we're just teaching people what we've been taught or we've taught ourselves. I mean, here's thanks for the internet. Bill Clinton said he wanted a computer in every household, so I guess it's about there so far. And we're just, it's a different way to communicate than, I have an old dial phone in a box, and I get it out and look at it sometimes, and I put my finger in the hole and turn it, and I thought, I just think, wow.
We've come a long way since then. Listen, Carl, good talking to you guys. We're going to say goodbye for now, but please keep us posted, and we'll keep you posted.
Thank you. Appreciate you guys coming on. Like I said, you've got good information that we don't have, but I know we're sitting on information that you guys probably don't have, and we can start sharing some of this stuff of what we have.
You bet. Sounds great. Loving it. All right, we'll talk to you guys again. Good work. Keep it up.
Thank you.
This is Bob signing off. Thank you very much for inviting us on tonight. It's been a pleasure, and we'll chat again.
Okay.
Thanks. Good night.
Thank you. Good night. All right, Carl?
Yeah.
Okay. All right, ladies and gentlemen, like I said, this is another approach. We have a gentleman that was a forensic auditor for the IRS. He actually worked for the system. He's retired. Now he is exposing the internal works of this stuff. This is very significant of what we're dealing with. But I also know with what we're dealing with out here on our site in this tax case that I'm working on, ladies and gentlemen, we are pulling congressional records that sit back and say on the floor of Congress that if the private individual, if they pay taxes, all they got to do is send in a form and they'll get all of it back, not some, not part, not a few. They are to get it all back. It is the public official side that is to pay the taxes, and they are the ones who have the income. The congressional records that we're pulling on this information, ladies and gentlemen, is devastating of how we are putting it into the tax court in D.C. They never anticipated this type of knowledge coming in. They never anticipated us going into the administrative side and going after them and exposing their corruption. This is a whole new aspect of what we're doing. The gentleman that I'm working with, he was a nervous wreck because him and his wife got nailed for almost $80,000 in fines for not filing paperwork in, not paying the taxes. And even though they filed the proper paperwork in, where they should have got a refund because they've got proof that if you do it this way, you'll get your refund. The system came back in and put the shit hooks to him. He found me. And I've been working with him for the last 5 months and walking him through this stuff, getting him to do the research. His whole attitude on this has changed 180 degrees. He is no longer upset, worried. He doesn't get sick to his stomach whenever he gets something from the mail. He looks forward to send him something so he can come back in and slam them. So he is doing real good on what we're doing. I just had another gentleman on a divorce case, which is on, who went into court here today over in Illinois, and the judge and then was talking about psychological, and this guy flat out asked him, do you have a degree in medical for psychological? And the judge says no. And he looked at the attorney, and the attorney said no. Well, then how are you making judgment if you don't have a degree? He put him back. They was not expecting this. But I've been working with him for 5 months. And he walked in and he walked back out of the court. They postponed. because what he was hitting them up on was their rules. And the judge says, oh, well, we're not going to put this in. He says, wait a minute, Your Honor. Pursuant to your rules of evidence, this has to be put in because your rule says it can be. And the judge just, like I said, from what he was in here saying, the judge got floored because he was hammering him on the procedure. He was hammering him on the rules. Ladies and gentlemen, there is a lot of merit of what we're teaching. A lot of merit.
Rod, you need to delete Derek 1488. Please.
1488. All right. Okay, well, I'm on my iPad, and the stuff isn't wanting to roll up like it was on my computer.
Yeah, so, Derek 1488, I don't know who you are. I don't care. But you have no business on here because your brain is incompetent of understanding where we've been and where we're going.
That's exactly right. Okay, what we're going to do, we'll just go ahead and shut this thing down for right now.
Okay, well, ladies and gentlemen, happy holidays. We'll get back to you after the first of the year. And God bless. And I will have to get you guys a new address for me because I have a new address. So as soon as I will get a new P.O. box, I will give it to Harvey to get it out to the callers for any donations and anything that comes in to a new address. Well, thank you guys for being on here. Ladies and gentlemen, have a good holiday, have a good Christmas, and have a good New Year's. And we'll talk to you here a little bit later when I'm feeling a little bit better because I'm back into coughing again. And we're going to give you some updates on this newer stuff that we're doing. So thank you for being in, and you all have a good night.